Those red and blue lights flash in your rearview mirror, and in that single moment, your entire evening, maybe your entire life, pivots on what happens next. Not on what you did wrong, not even on what the officer suspects. It pivots on what you know and what you say in the next 60 seconds. Most Americans don't know enough. And the system, the courts, the training academies, the legal machinery built around traffic enforcement is counting on that ignorance every single time. This is the conversation nobody is having loudly enough. A Supreme Court ruling that every gun owner, every driver, every American who has ever been pulled over needs to understand right now, because right now, in 2026, with police interactions making national headlines every other week, with dash cam footage flooding social media, with civil rights lawsuits piling up in federal courts across this country, the average American still doesn't know what they're legally required to do, what they absolutely don't have to do, and exactly where that line sits. And that gap in knowledge isn't an accident. That gap is profitable for the system, not for you. Before we go any further, if you care about your constitutional rights, if you believe that ordinary Americans deserve to know the law that governs their own lives, hit that subscribe button right now and turn on notifications. Because this channel exists for one reason, to hand you the information that power would rather keep behind closed doors. Subscribe, because knowledge is the only armor that actually works. Picture this clearly. You're driving home. It's a Tuesday. Nothing remarkable about the day. You're 5 miles over the speed limit. Maybe you didn't even notice the lights come on behind you. You pull over, hands gripping the wheel a little tighter than usual, because no matter how law-abiding you are, those lights trigger something primal. The officer walks up, takes your license and registration, goes back to his cruiser. Standard procedure. You breathe, you wait, and then he comes back. And something about his posture is different, and something about the way he's looking at you has shifted. And then he says it four words, step out of the vehicle. Your stomach drops. Because instinctively, every human being understands that those 4 words mean something more than a conversation just got started. Those 4 words mean the rules just changed. And they have, but not in the way most people think. The majority of Americans in that moment do one of 2 things. They comply, completely rolling over, answering every question, consenting to everything, handing the officer a fully constructed case against themselves without ever being asked directly, or they resist, voice rising, citing rights they don't fully understand, coming across as confrontational in a way that gets noted, recorded, and used. Both responses are traps. Both are exactly what the system anticipates, and both can end with you in handcuffs when you had every right to drive home. Here's what you have to understand about how a traffic stop actually functions from a law enforcement perspective. It is not a conversation between 2 equals. It is a structured information-gathering exercise. The officer who walks up to your window has been trained, specifically and repeatedly, to move through a sequence of steps designed to gather evidence, create legal justifications for further investigation, and document your behavior in a way that supports whatever decision he's already leaning toward making. That training is not secret. It's taught in academies across the country. It's been refined over decades of court decisions that have step-by-step expanded what officers can do during a stop that begins as nothing more than a minor traffic violation. The officer's not improvising. He has a script. And until now, you didn't have one. That's the real imbalance. Not race, not geography, not what you're driving, though. All of those things matter and complicate the picture significantly. The fundamental imbalance at the core of every traffic stop in America is information. He knows exactly what he's doing and why. Most people in that driver's seat have no idea what's coming next. The moment you step out of that vehicle, 4 distinct legal and tactical mechanisms activate, and most people aren't aware of any of them. Each one is a thread. Pull any of them wrong and the whole thing unravels. Together, they form a net that the average American walks directly into without ever seeing it coming. The first is the plain view doctrine. When you're sitting in your car, the officer's view into your vehicle is naturally limited. He can see what's visible through your window, but your physical presence, your body, the angle, all of it restricts his line of sight. The moment you open that door and step out, you've changed the geometry. Suddenly, he has a clear, unobstructed view into your entire vehicle, that bag on the back seat, that container on the floor. That item you've had rattling around in the cup holder for 6 months and completely forgot about. Under the plain view doctrine, if an officer can see something from a position he's lawfully occupying, he doesn't need a warrant. He doesn't need your permission. He needs only to articulate that the item was in plain view and appeared suspicious. You standing up didn't feel like a legal act, but legally, it was one of the most consequential things you did that night. The second mechanism is field sobriety testing. Once you're outside the vehicle, nervous, standing on the shoulder of a road with cars passing at 60 miles an hour, the officer may tell you he detects an odor, maybe alcohol, maybe something else. And then comes the request. Walk this line, stand on one leg, follow this object with your eyes. These tests sound simple. They are not. They are designed, in part, to be failed under pressure. Neurological research is clear that stress, cold temperatures, uneven pavement, poor lighting, and anxiety all degrade physical performance. A person who has consumed 0 alcohol can fail a field sobriety test. And the vast majority of people asked to perform these tests don't realize they are under no legal obligation to do so. They think refusal looks guilty. It doesn't. It looks like someone who knows their rights. The third mechanism is the Terry frisk, named for the 1968 Supreme Court case Terry versus Ohio. Under that ruling, an officer can conduct a pat-down search of your person if he has a reasonable, articulable suspicion that you are armed and dangerous. What gets lost in practice is that word articulable. He must be able to state a specific reason. Your nervousness alone is not sufficient legal grounds. Despite what some officers will tell you or imply, the problem is that once his hands are on you, the search frequently extends well beyond what the law technically permits. And in the moment on the side of that road, most people don't push back because they don't know they can. The fourth mechanism is conversation. This is the one that does the most damage, consistently, reliably, across every demographic, in every state. Once you're out of that car and standing there uncomfortable and exposed, you will want to explain yourself. That's human nature. That's not weakness. That's how people are wired. And the officer knows it. He's trained to encourage it. He'll be friendly. He'll nod. He'll act like you're on the same team. And every single word you say is being recorded, documented, and potentially reframed in a police report written hours later in a quiet office by someone whose job is to build a case. Let's talk about the two kinds of people who get it wrong, because understanding both failures is just as important as understanding what to do right. The first type, the over-cooperator, is the person who genuinely believes that compliance equals safety. And to be fair, that instinct comes from somewhere real. For many Americans, particularly those who grew up in communities where challenging authority felt dangerous, compliance is a deeply conditioned survival strategy. Step out of course, walk the line, absolutely search the car, go right ahead, I've got nothing to hide. This person thinks they're defusing the situation, and what they're actually doing is constructing the prosecution's case, piece by piece, with their own hands. The second type is the aggressive refuser. This is the person who has watched enough YouTube videos about constitutional rights to feel confident, but not enough to understand the crucial distinction between what the law permits and what the law requires. I'm not getting out of my car. You can't make me. I know my rights. And here's where it collapses. Because the officer then notes in his report suspect was agitated, uncooperative, made furtive movements, and appeared threatening. Every one of those phrases is a legal key, a key that opens the door to a search without your consent, a claim of officer safety, an escalation that ends with you on the ground or in the back of a cruiser. What's infuriating about both failure modes is that the system is specifically designed to push you toward one of them. The script that officers are trained to use is engineered to provoke either panic-driven compliance or anger-driven resistance. Because either one benefits the state, either one gives the officer something to work with, and the calm, informed, legally precise response, the one that neither resists nor surrenders, is the one the system least prepares you for and most wants to prevent. Because that response is the only one that actually protects you. Think about this from the officer's perspective for a moment. Not to excuse anything, but to understand the machinery. He does this every single day. This is routine. He's not nervous, you are. He knows where the conversation is going. You don't. He's done this hundreds of times. You've maybe been pulled over twice in your life. The asymmetry isn't accidental. It's structural, and it's been upheld repeatedly by courts that have consistently ruled in favor of expanding law enforcement authority during traffic stops. If this kind of information matters to you, and it should, because one day you will be in that car, share this with someone you care about right now. And subscribe if you haven't already, because the information in the second half of this commentary is something that legal professionals charge hundreds of dollars an hour to explain. Now let's talk about the Supreme Court ruling that sits at the center of all of this. Pennsylvania versus Mimms, decided in 1977, and in 2026, it is still the controlling precedent that officers rely on every single time they say those four words. Here's what the court actually held. During a lawful traffic stop, a police officer may order the driver to exit the vehicle, full stop. No probable cause required, no reasonable suspicion beyond what justified the initial stop. If the stop itself is lawful and a 5-mile-per-hour speeding violation is entirely lawful, the order to exit is lawful. The court's reasoning was straightforward and deeply telling. The officer's interest in personal safety outweighs the driver's interest in remaining seated in their vehicle. That's the trade the court made. Your physical comfort, your privacy, your psychological advantage of being behind the wheel, all of it subordinated to the officer's safety calculus. Several years after Mimms, the court extended this logic even further. Maryland versus Wilson, decided in 1997, held that officers could also order passengers out of a stopped vehicle. Not just drivers, anyone in the car. The court applied the same reasoning, officer safety, and expanded it to cover every occupant of the vehicle, which means that if you're a passenger on your way to dinner and the driver gets pulled over for an expired registration, the officer can legally order you onto the pavement as well. Now here's where the deception begins. And I use that word deliberately. The way these rulings have been applied in practice has routinely exceeded what the court actually authorized. Mimms said you must exit the vehicle. It said nothing about consenting to a search. It said nothing about performing field sobriety tests. It said nothing about answering questions beyond basic identification requirements. It said nothing about submitting to a pat-down absent the specific conditions required by Terry. But in the gap between what the ruling actually says and what officers sometimes imply in the field, a whole universe of unconstitutional conduct has taken root. Officers routinely act as though the order to exit the vehicle is the opening of a much broader authority. And because most people don't know where Mimms ends and the Fourth Amendment begins, they go along with it. This is not a criticism of every officer. The majority of law enforcement professionals conduct traffic stops correctly and professionally. But the system, the legal architecture, the training incentives, the pressure to make arrests, write citations, generate statistics, creates conditions where the line between lawful investigation and unconstitutional overreach gets crossed regularly. And when it gets crossed, the person standing on the shoulder of that road is almost always the last one to know it. So what do you actually say? Because knowing that you have rights and knowing how to assert them in the moment are two completely different skills. The words matter, not just legally, but tactically. And I'm going to give them to you exactly. When the officer tells you to step out, you step out. You comply because Mimms requires it. But as you're stepping out, or immediately after your feet hit the pavement, you say this clearly and calmly, "Officer, I'm stepping out as you've requested. I do not consent to any searches. Am I free to go, or am I being detained?" That's the framework. Every single word in it is load-bearing. Start with compliance. I'm stepping out as you've requested. This does three critical things simultaneously. It documents your cooperation. It prevents the officer from characterizing your behavior as resistant or suspicious. And it puts on the record and on the dash cam that you are exiting because you were told to, not because you're inviting further investigation. The distinction matters enormously in court. And then the non-consent clause, I do not consent to any searches. This is not aggressive. It is not confrontational. It is a clear, legally operative statement that creates a record. If the officer searches you or your vehicle after you've said those words and he lacks the probable cause required to do so without consent, everything he finds can be challenged under the exclusionary rule. The evidence doesn't automatically disappear, but you've created the foundation for a suppression argument that might just mean the difference between a conviction and walking out of a courtroom free. And then the detention question. Am I free to go or am I being detained? This forces a legal choice. The officer must now decide. If you're free to go, the stop is over, you thank him politely and you leave. If you're being detained, he has to articulate why. And articulation is the enemy of fishing expeditions. Officers who are hoping to discover something rather than investigating something specific don't want to be put on record, justifying their detention with specific facts. When the officer pivots and says he'll let you go if you just take a quick sobriety test, and he will say something like this, because it's part of the script, your response is equally precise. Officer, I exercise my right to decline field sobriety tests. Nothing else, no explanation, no apology, no elaboration. The moment you begin explaining why you're declining, you're giving him material to work with. The law does not require you to explain the exercise of your constitutional rights. You are not obligated to make his case easier. And when he uses the oldest line in the enforcement playbook, if you've got nothing to hide, you'll let me search. Your answer is this: Officer, I am exercising my constitutional rights. That is not evidence of anything, and it isn't. Every federal circuit court that has addressed this question has held that the exercise of constitutional rights cannot be used as evidence of guilt. It cannot be cited as a basis for reasonable suspicion. It cannot be used to justify a detention. You are on solid legal ground. Say it clearly, then stop talking. But what happens when the officer ignores all of it? What happens when you've said every right word, stated your non-consent clearly, and he searches you or your vehicle anyway? Because this happens. It happens more than most people realize. And this is the moment where the most dangerous mistake of the entire encounter occurs, because the emotional response, the one that every human being feels when their rights are being violated in real time in front of them, is to resist, to push back physically, to raise your voice, to demand that he do not do it. Not because your anger isn't justified. It may be entirely justified, not because your rights aren't being violated. They may be clearly and obviously violated. But because the roadside is not your courtroom, and the officer knows that, the moment you raise your hand or raise your voice past a certain threshold, or make any movement that he can characterize as threatening or resistant, you have just handed him the arrest he may have been fishing for all along. Resisting arrest charges are easy to file and hard to fight, and they can follow you for years. Instead, you do this. You reiterate calmly, clearly, for the record and the camera, that you do not consent to this search. And you say it once more, Officer, I do not consent to this search. And then you go silent, completely silent. Because from that point forward, your fight is not happening on that roadside. It is happening in a courtroom, potentially months later, where a judge will review the dashcam footage, hear the testimony, read the report, and decide whether the officer had the legal authority to do what he did. Under the exclusionary rule established in Mapp v. Ohio, evidence obtained through an unconstitutional search cannot be used in court. That means if the officer found something during an illegal search, his entire case may collapse before trial. Under 42 U.S.C. Section 1983, the Federal Civil Rights Statute, you may have the right to sue the officer and the department for violating your constitutional rights. These are not theoretical remedies. People win these cases. Departments pay settlements. Officers face consequences. But none of that is available to you if you made the roadside your battleground, because then the story becomes about your behavior, not his. The system wants you to believe that your only options are total submission or total resistance. That is a lie told by people who benefit from your ignorance. The truth is that a calm, legally precise, firmly stated assertion of your rights followed by strategic silence and documented non-consent is the most powerful thing you can do in that moment. Not because it will necessarily stop the officer from doing what he's going to do, but because it creates the record that dismantles his case in the forum where these battles are actually decided. Attorneys who specialize in civil rights litigation look for exactly the kind of clean, documented, non-confrontational encounters we've described. They look for clients who said the right words, didn't escalate, and have dash cam or body cam footage that shows precisely what happened. That footage, combined with your clearly stated non-consent, is the foundation of a winning case. The officer's badge protects him on the street. Your words and your silence protect you in court. Every American driving a car in 2026 needs to understand this framework, not because every traffic stop is adversarial, not because every officer is corrupt or malicious, but because the law is not automatically on your side just because you're innocent. The law is on your side when you know it. Invoke it correctly and create the record that proves it was violated. That's the system we live in, and it's not going to change because we're uncomfortable with it. It's going to change when enough ordinary Americans understand it well enough to hold it accountable in courtrooms, in elections, in the choices they make about who to vote for and which policies to support. The Supreme Court gave officers the authority to get you out of your car. It did not give them authority over your silence, your non-consent, or your rights. Know the difference? Say the word, stay calm, and take your fight to the arena where it was always meant to be decided. If this video helped you understand something you didn't know before, and I believe it did, then do one thing right now. Subscribe to this channel, leave a comment below telling me what surprised you most about what you just heard. And share this with at least one person in your life who drives a car, because information shared is power distributed. And right now, the power in this country is distributed very unevenly. We're here to help fix that. One video, one viewer, one subscriber at a time. Stay informed, stay protected, and don't ever let ignorance of the law be the thing that costs you your freedom.